Okay, so um, I've been looking through this material in the Indian Constitution, and, well, something about its preamble really jumped out at me.
Oh, yeah. What's that?
It just raises these fascinating questions, about how a nation's core document, how it's formed, and maybe how it changes. We sort of think of them as set in stone, don't we?
We definitely do. Immutable foundational texts.
Exactly. But what if, like, a key part isn't quite what it seems? So today we're doing a deep dive into the Indian Constitution, really focusing on this idea of secularism within it.
Sounds good.
And our main source here is Dr. Ryan Baidya's book, A New Democratic Republic Constitution for India. We're specifically looking at the chapters clarifying the preamble, and another one called The Indian Constitution, in its current form, has failed to maintain a truly secular state.
Right. Pretty direct titles there.
Yeah, no kidding. So our mission really is to try and uncover some historical bits, explore how secularism has been, well, defined and maybe practiced in India, and kind of understand what the Constitution's current setup means for you, the citizens. Okay, let's unpack this. There's a fascinating story here, I think.
It's definitely a critical look. It's not just about legal stuff, is it? It questions the sort of historical honesty of the document itself.
Precisely. Let's start right there at the beginning. The preamble, Dr. Baidya calls it the vital part, the bit that holds all the core values. What did that original preamble actually say?
Well, when it was adopted, November 26, 1949, the text was quite clear. It read, "In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution."
Just that.
That was the core adoption statement, signed and given on that date.
Okay, but here's where, according to Dr. Baidya, it gets, well, complicated. Much later, 1976, the 42nd Amendment Act adds three really big words: socialist, secular, and integrity.
And critically, that was during the emergency.
Right, under Indira Gandhi, a very charged period in Indian history.
Definitely. And the discrepancy, as the author points it out, is pretty stark. The preamble we see today, the one with those 1976 words, it still carries the original date, November 26, 1949.
Okay. I see the issue.
Yeah, so it gives this impression, maybe unintentionally, maybe not, that the current wording, including socialist and secular, was agreed upon way back in 1949 by the original Constituent Assembly.
Which it wasn't.
Which it absolutely wasn't. It's historically inaccurate. And Dr. Baidya, well, he doesn't hold back. He actually calls this a legal forgery.
Wow. Legal forgery. That's strong.
It is, because it presents the amended text as if it were the original unedited version from 1949.
So if that's the problem, this sort of historical misrepresentation, what does the book suggest? How do you fix that to maintain, historical and legal honesty? It feels important for a country's foundational text.
Yeah, absolutely. Dr. Baidya lays out four main ideas for rectification. First, an annotated preamble. Basically, future copies should have footnotes or maybe an appendix.
Making it clear what was added when.
Exactly. Second, explicit documentation. So like a statement right in each copy saying, look, socialists, secular, and integrity were added by the 42nd Amendment in 1976.
Just spell it out.
Spell it out. Third, a public awareness campaign. Use official channels, education, whatever, to let people know how the preamble actually evolved.
Okay, it makes sense.
And finally, he even gives a revised text example, something like, in our Constituent Assembly, this 26th day of November, 1949, do hereby adopt, enact, and give to ourselves this Constitution. Then maybe a sentence directly after. The terms socialist, secular, and integrity were added by the 42nd Amendment Act in 1976.
Clear, simple, historically accurate. This whole issue of transparency in such a core document really sets the stage, doesn't it? It connects directly to the bigger argument Dr. Baidya makes.
It really does.
Yeah.
Because the book then moves on to this much broader claim. The Indian Constitution, in its current form, has failed to maintain a truly secular state.
Okay, that's the headline argument.
That's the headline. And to really get what he means, we first need to understand what the author thinks a truly secular constitution should look like. What's the ideal?
Right. So what are those key features, according to the source?
Well, fundamentally, it starts with the separation of religion and state. Pretty clear, right? No official state religion. Religious groups don't run the government. Government works independently of religious rules.
Okay. Separation, what else?
Equal treatment of all religions. No favorites, no special privileges for one group over another. Then freedom of religion. Everyone has the right to practice their faith, change it, or have no faith at all.
As long as it doesn't harm others or public order, presumably.
Exactly. That's the usual caveat. Also, crucially, no religious tests for public office. Your faith, or lack of it, shouldn't determine if you can hold a government job.
Makes sense.
Then there's secular education. Public schools shouldn't push any particular religion. Any religious education offered should be, informational, not trying to convert people.
Neutral.
Neutral, yes. And finally, neutral laws and policies. Laws should be based on reason, evidence, the common good, not on religious doctrines.
And the book points to examples of this in practice.
It does. The U.S. Constitution is one. The First Amendment has the Establishment Clause, no state church, and the Free Exercise Clause. Plus Article 6 saying no religious test for office.
All right.
And the French Constitution is another key example. Article 1 calls France secular. They have this principle of laïcité, separation of church and state, government neutrality. It's deeply embedded.
So why does this matter? Why strive for this kind of secular constitution?
Well, the idea as presented is that it promotes equality, it protects everyone's individual rights, helps prevent conflict between groups, and encourages sort of rational, evidence-based governance. What's fascinating here is how these principles are really designed to build a cohesive, harmonious society.
Okay, so that's the ideal, the framework. Now let's dive into Dr. Baidya's main argument. How the Indian Constitution, even with secular in its preamble now, is argued to have, well, failed to really live up to this ideal. He mentions amendments, court rulings, laws. Where does he start building this case?
He lays out several key points. The first one is a big one, personal laws based on religion.
Ah, yes, this is quite well known about India.
It is. You have different laws for Hindus, Muslims, Christians, Parsis, covering really personal stuff. Marriage, divorce, inheritance. Dr. Baidya argues this patchwork system directly contradicts the idea of everyone being equal under one law.
Even though the Constitution itself suggests a uniform civil code.
Exactly. Article 44 points towards a uniform civil code, a single set of laws for everyone, but it's a directive principle, not strictly enforceable, and it hasn't been fully implemented. So these separate personal laws continue.
Okay, so inconsistent application of law is point one. What's next?
Point 2 is state intervention in religious institutions. The book points out that in many Indian states, Hindu temples are actually managed or controlled by government-appointed boards.
Right.
But places of worship for many other religions, like mosques or churches, are typically managed independently by their own communities. This difference, the author argues, suggests unequal treatment by the state. It doesn't look neutral.
That does seem like an imbalance, yeah. What about special provisions? Does the Constitution itself create differences?
That's the third point. Special provisions for specific religious communities.
Mm.
Article 30, for example, gives religious and linguistic minorities the right to set up and run their own educational institutions.
Which sounds like protecting minorities, on the face of it.
It does, and that's the intent. But the critique in the book is that this can end up promoting specific religious ideologies within those schools and might sort of encourage separation rather than integration into the broader society. Article 29, protecting minority interests, is also mentioned as sometimes working against uniform secular principles.
And money. Does state funding come into it?
It does. Point 4 is financial support for religious activities. The author mentions the Hajj subsidy for Muslims, which existed for decades before being phased out in 2018. That was often cited as preferential treatment.
Okay, even if it's gone now, it was a factor.
It was. And apparently, various state governments still provide funding for pilgrimages to specific religious sites for certain communities. The argument is, again, this violates state neutrality. The state shouldn't be funding religious activities.
Right, that seems to blur the lines quite a bit. What about schools and quotas?
That's point 5. Educational institutions and religious quotas. Minority-run institutions can often reserve a pretty large chunk of their seats for students from their own religious community. Dr. Baidya sees this as preferential, not really fitting with a truly secular education system that should be open to all based on merit. He also points to Articles 25-28, which allow religious instruction in state-aided institutions. This, he feels, blurs the lines and creates, he uses strong words here, chaos, mistrust, confusion, corruption, and vote banking.
Vote banking, that term again. Can you just quickly explain what's meant by that in this context?
Sure. Vote banking, essentially, is when political parties target specific religious or caste groups, promising them tailored benefits or policies, not for the common good, but specifically to secure their block of votes.
Ah, I see. Treating communities as voting blocks.
Exactly. And Dr. Baidya argues this really undermines genuine secularism because policy decisions get driven by winning over these specific groups rather than by impartial principles that apply to everyone, which leads directly into his sixth point: political exploitation of religion.
So politicians using religion to win elections.
Pretty much. He argues that parties actively leverage religious sentiments, making promises, stirring feelings, all for electoral gain. This naturally leads to policies that might favor one community over another, again, moving away from impartial secular governance.
Okay. And the last point, it was about the courts.
Yes, the seventh point is judicial interpretations. The argument here is that some Supreme Court rulings have been perceived as favoring certain religious communities, or perhaps bowing to religious pressure. The classic example cited is the Shah Bano case.
Right, involving maintenance for a divorced Muslim woman.
Exactly. The court initially ruled in her favor based on secular law, but then there was significant pressure, and the government passed the Muslim Women Act in 1986, which effectively overturned the court's secular approach for maintenance in such cases. Many saw that as the state conceding to religious demands, undermining the secular legal principle the court tried to uphold.
Okay, so if we pull all that together, the argument is that even though India declares itself secular, the way things have worked out with personal laws, state involvement in temples, special provisions, funding, education quotas, politics, even some court actions, it's led to a situation where different groups are treated differently. It's not the clean separation and equality the ideal demands.
That's the essence of the critique, yes. Preferential treatment creeps in, and the true essence of secularism, as the author puts it, gets lost in the implementation.
So Dr. Baidya then looks at specific parts of the Constitution itself to show how this plays out, how it tries to juggle secularism with accommodating all these diverse groups.
Precisely. And he argues this very attempt at balancing this complex structure is what actually fuels the problems, the chaos, mistrust, confusion, corruption, and vote banking we mentioned. His point is stark. Giving privileges to one group inherently means other groups don't get those privileges, which means they aren't being treated equally.
It's a zero-sum game in his view.
It seems that way in the critique. He sees it as inherently creating inequalities.
Okay, can you walk us through some of the specific articles he mentions? Which groups get what kind of provisions, according to the book?
Sure, he breaks it down. For Muslims, Articles 29 and 30 are key protecting cultural and educational rights, allowing them to run their own institutions. Also, Articles 341 and 342 on affirmative action or reservations have been applied to certain Muslim communities identified as backward. And Article 25, 2b, which originally mentioned opening Hindu institutions, has sometimes been interpreted to apply more broadly.
Okay, and for Christians?
Yes.
Similar things?
Yes, pretty similar. Articles 29 and 30 apply to them as a minority group for cultural and educational rights. And like some Muslim groups, certain Christian communities also benefit from affirmative action under Articles 341 and 342.
Right. Now, what about Hindus, the majority community? Are there specific provisions mentioned for them?
There are. Article 25, 2b explicitly talks about opening Hindu religious institutions to all classes and sections of Hindus, sort of an internal reform aspect. Article 26 gives religious denominations, including Hindu ones, the right to manage their own religious affairs. And there's Article 290a, which is very specific. It mandates annual payments from state funds to the Devaswam boards managing certain Hindu temples in Kerala and Tamil Nadu.
Ah, so direct state funding in that case.
Yes, enshrined right there.
What about other significant religious groups? Sikhs, Buddhists, Jains?
They generally fall under the broader minority rights protections in Articles 29 and 30. And Article 25, the Freedom of Religion article, applies universally, covering their rights to practice, profess, and propagate their faiths.
Okay. And finally, what about people who aren't religious? Atheists, agnostics? Does the Constitution protect them too?
Yes, the source acknowledges that. Article 15 prohibits discrimination on grounds of religion, which includes lack of religion. Article 16 ensures equal opportunity in public employment. And crucially, Article 25(1), guaranteeing freedom of conscience, is interpreted to include the freedom not to believe, protecting atheists and non-religious individuals.
So the framework tries to cover everyone, but it does so through these varied, sometimes group-specific provisions. And we should also remember those big amendments, right? The 42nd adding secular, and the 93rd allowing special provisions for backward classes, SC, SESTs, which can overlap with religious minorities.
Exactly. Those amendments layer onto this complex structure, and this leads to a really crucial point the author makes. From the perspective of Hindus, the majority community, all these provisions and how they're sometimes applied can feel like they're being marginalized or disadvantaged.
So a perception of reverse discrimination, perhaps.
That's the implication in the source, yes. That the effort to accommodate minorities, combined with things like state control of temples, can lead the majority to feel they aren't getting equal treatment, which challenges the whole notion of secular fairness.
Which brings us right back to that central tension, doesn't it? The ideal of secularism clashing with the reality of implementation in India's incredibly diverse society, leading to these perceptions of unequal treatment.
Exactly. And Dr. Baidya's concluding thought, as presented in the book, is quite sobering. He argues the Constitution's current structure itself is part of the problem, leading to these implementation challenges. He suggests it's not rooted in the nation's diverse cultural and religious landscape in a way that actually works smoothly.
And the really striking part.
Yeah, he basically says that just tinkering with more amendments might not cut it anymore. He suggests constitutional amendments may not be a suitable solution for much longer.
Wow. So not just amendments, but something bigger.
That's what he hints at. The source puts forward the idea that maybe a comprehensive overhaul and complete rewriting with inclusive policies is needed to make the Constitution truly serve all citizens fairly and effectively.
A complete rewrite. That's a huge thought. So for you listening, consider that. What would a total overhaul of a nation's constitution, especially one as diverse as India, even look like? How could you possibly balance history, culture, religion, and a modern vision of true equality for every single citizen in such a fundamental rewrite? It's definitely a challenging idea to mull over.